Hi, sorry about the long pause in the beginning. I apologize for that. This is Professor McLaughlin. This is a lecture on Kubasek's Chapter 35, Forms of Business Organizations, with a special focus on the cases in this chapter. So just like many other decisions about whether you want to collaborate in a group, as a team, go it alone, seek an opportunity that is prepackaged, or create your own opportunities, the same decision-making paradigm or parameters exist when business persons or even existing entities decide how they want to form their business. So we saw in chapter 6 of the textbook that for businesses considering how to form themselves to function internationally, there's lots of different choices. And one of those choices was to organize themselves as a joint venture. And we'll revisit that type of organization in chapter 35 as well. But also individuals make decisions on how to form their business, and frequently it can be framed in a similar way, whether they're deciding to go into a sole proprietorship where management and control is embodied in one person, a partnership where management and control liability is in two or more persons, sharing burdens, splitting risks, limited partnerships, and then finally corporations where management and control is run by employees, owners are shareholders, and the corporate entity itself exists outside of those individual employees and individual shareholder owners. And each of those forms has a specific benefit, and that caused a group or a individual to choose that as the form of their business organization. So what this chapter does is introduces you into those forms, and what this lecture will do is help you focus on what the similar variables are between those organizations. And those variables are management and control. Who controls this entity? Sole proprietor, it's just you. General partnership, it's 50-50 or split 3 ways. Limited partnership, it's split in different ways. And corporation, management and control, and the employees. Liability, tax liability, legal liability for torts, for premise liability, liability for somebody coming into my business and slipping and falling. Sole proprietor, it's me. General partner, I mean, it really depends. Does your partnership have a storefront? Or, what kind of legal liability might you have? Limited partnership, and then corporation. So what I'd like you, as I go through this lecture, to do is think about those variables. And finally, so it's management and control, liability, tax, legal, debts. How easy is it to form the corporation? And then finally, what's the fourth one? How easy is it to form the corporation, management, and control? Maybe that's all of them. The formality for, the fourth one is transfer of ownership, which is a funny one. We'll touch on that. Some formations, there really is no way to transfer ownership, so I'm kind of taking that off of my variable list. It can be a reason, and each of these variables is a reason why that form of business was chosen, why that particular organizational structure was chosen. All right, so let's get going with the slides and take a look at our various forms of business, wrapping up with the cases in this chapter, which are really, really interesting and will certainly be on the exam in my classes this summer. So how are entities deciding to form themselves? Are they going to be a sole proprietor? Are they going to be a C Corp? Will they be an S Corp? So the major forms of business, sorry, I keep fooling around with this. It's probably pretty irritating, are sole proprietor, general proprietor, limited partnership. I think I got it right. I'm so sorry. That's so not cool. Sole proprietor, general partnership, limited partnership, and corporation. So the major forms that we're going to look at. And then finally, we also have a bunch of slides on franchises. So franchises are very important. Whether you decide to go in one can have the same variables as a, whether you would decide to be a corporation or a general partnership. It's kind of a hybrid. It's very contractual by nature. You're essentially entering into an agreement with a franchisor, and you're very limited. And so I would argue that there are secondary and non-similar kind of reasons why you would choose a franchise as opposed to a general partnership, limited partnership, corporation, or sole proprietor. But we'll get into that a little bit later. Having tech issues. Okay, sole proprietors. It's just one person. It's you, yourself, and you. And you are the owner. You have total control. You have unlimited liability if something goes wrong. If you have a tax debt. If you have a loan that must be repaid. And also you're taxed as an individual. So you're taxed as the person, the individual that you are, as opposed to being taxed as an entity. So you're the center of your universe. It's very easy to form. There can be more than one employee, but you're the sole owner. You could have a donut shop where you're the sole owner, but you have employees that work in it. So the advantages are it's very easy to start up. You have total control. Disadvantages, you're personally liable for everything, for business debts, for tax debts, for obligations, for maintaining inventory, all of that stuff. Now, what about funding? This is a very important distinction among the different forms of business organization. Because as you saw in the beginning of this chapter, Facebook, that's not this chapter, it's chapter 38. But we'll see in chapter 38, Facebook had to go public or chose to go public because it had hit the maximum number of shareholders for the state of California. And so if it wanted to raise money to go buy the next big thing or get bigger and global and massive, that cannot be done if the funding is limited to a loan to you as an individual. Even if you are Mark Zuckerberg, you cannot personally raise that kind of funding. The funding will be limited to maybe him when he was at Harvard, not now. But for individuals as a sole proprietor, if you're going to get a loan, it's going to be a loan from a bank. That's going to be based on the collateral and assets that you currently have, which, even if you're rich, doesn't compare to what a corporation could come up with, multi-million dollars in income and revenue each year that can be relied upon by the bank to give you funding. And on top of that, you can raise funds through debt, issuing debt, or issuing equity, which is a very big reason why corporations are chosen as a form of business organization, so that funding can be achieved at that level. So here you are, this image, the sole proprietor doing everything, managing everything. It's just you alone. Now, why would people choose a general partnership? So for exactly the same reasons why you might not want to live alone or study alone or drive long distances alone. You share the benefits and the burden, even if the partner is irritating. There are benefits. A general partnership, we're going to say it's going to be 2 persons, can be more. You share equal control. You can agree to share unequal control, but equal's good. Let's keep it simple. Each partner has unlimited personal liability for debts and obligations. And the profits are taxed as income to partners, as individuals. And we're going to keep it super simple like that. For those of you aware that there are, partnership schedules and equity that gets paid into the partnership, for our purposes, we just want to understand the benefits of the partnership is the sharing of the burdens and the risk, and you also share the profits. It's quite easy to start up. You can file partnership forms with the state of California. All of these forms of business org, and when we say forms, all of these 2 different meanings of the word, when you file the forms necessary to become a partnership or a corporation in California, that's different than choosing the formation of your business. But in the state of California, and all of these formations of business are governed by the state for the most part. To the extent the federal government gets involved, it's usually at the level of taxation or criminal penalties should your corporation or corporate executive do something that's worthy of the government's attention and it's illegal. You do not have to have a partnership agreement, but that's can be very problematic. If you are prudent and risk averse, having a partnership agreement is super easy to do. In the state of California, you just go to the website and fill it out, pay your fee, and bam, it's proof that your partnership exists and that this is the agreement and this is the split, and nobody can deny it. And also, if people want to find you, all your information is there, registered with the state. That gives other businesses that deal with you a level of comfort. It gives banks a level of comfort, and it's probably good business. But having said that, partnerships don't have to have them to exist. So advantages of partnership, it can be very easy to create one, and partnership income is partner income. It's just income to you. Problems may be, what if your partner is not a good partner and writes a lot of checks or spends all your money or obligates the partnership to obligations or contractual obligations or vendor relationships that you would not have agreed on and they didn't consult you. So having a bad partner potentially is a very big disadvantage for partnerships. Now, there's something also called a limited partnership, and this is very specific. So the limited partnership is an opportunity for a group to contribute a capital contribution, that's cash, to an enterprise, a partnership, but only be liable up to the capital contribution. So for general partnership, you're 50% liable, the other partner is 50% liable. You're both liable for everything. So that can exceed whatever your contribution is. If your contribution is working or money, or you sold your house to be part of this general partnership, There is no limit to your liability, but for a limited partnership, it's structured so that you have at least one general partner, and the general partner is in control of the managing and the operation of the business, and the limited partners are really just giving cash, and they are making that capital contribution, has no input in the managing and operation of the business. And should something go wrong, it's a beautiful thing. They're only limited by the dollar that they put in, the dollar amount that they put in, and the general partner is running the business. So here, I'd like you to take a step back and how did all of these possible formations of business come about? Some of them are very historical. But for the most part, many of them are created through necessity or through business and business persons looking for ways to invest, to be profitable, and to create new structures that allow them to achieve whatever their goals are. So if your goal is to contribute to an enterprise but only be limited by your capital contribution, then you may encourage your state legislator, all your business trade organizations to create this kind of partnership. So many of these formations of business organization were created over time through business need, and as business developed in states and nationwide, and as business grew more creative and began to look for new ways to collaborate while limiting liability and limiting and keeping certain tax structure, these types of organizations became part of state law. So what I'd like you to do with this chapter is, rather than simply memorize them, try and understand that historically this came from a group who wanted to achieve something, and then the state eventually formalized it. And also understand that there are arrangements informally going on all the time that we know nothing about. And that's interesting for business as well. Okay, the corporation. Why would somebody want to be a corporation? Corporations provide a separate entity that is responsible for all liability. Owners or shareholders of the corporation, whether it's public or private, or whether it's a publicly traded corporation or a private corporation, they're limited to the amount of their investment in the corporation, and they are not liable for acts of the corporation because the corporation has a legal identity that's separate from its owners or its shareholders. And that has even grown over time and over decisions of the U.S. Supreme Court into granting corporations fundamental rights to contribute to campaigns. We saw from Chapter 5 you have commercial speech rights and that kind of thing. So there are rights that the corporation has that have developed over time through decisions by the courts, but also rights that were just part of commercial speech that corporations have as well. So corporations are taxed at the corporate level, and then any distribution of the corporation is also taxed to the shareholder or the owner. So I have a business, and my business is to make soap. I incorporate. I make a lot of soap. I sell it. I pay myself an income. My business is a corporation. I'm an owner. I'm also a shareholder. That corporation must pay tax on all the income of the corporation, and that's part of me. So I make sure the corporation pays tax on that income. And then that same profit, that same income that came through the corporation to me, I also have to pay as an owner, or if it's a distribution to me as a shareholder, I've got to pay that as well, and we call that double taxation. SCorps can avoid that double taxation. So corporations have limit the liability of owners and shareholders. Typically, employees are not responsible for the bad acts of a corporation. We saw a couple cases throughout the early chapters where corporate executives, well, in Chapter 7, corporate executives can be found criminally liable for things reaching through the corporation to the employee, but that will be in very specific situations where the corporation is involved in something that, as the case of US v. Park, it was food related, there was a public health issue, that kind of thing. So advantages of corporations: limited liability, and the ease of raising capital by issuing stock. It's huge. Disadvantages: double taxation, and also extreme formalities required in setting up the corporation, maintaining the corporation. You have to pay fees to the state, you have to file the forms, you have to have meetings. There's a lot of formalities required. And corporations need to be legitimate entities that exist for the not just as the hollow shell of the owner's wishes, but as something separate, actually engaging in separate activities. So the corporation cannot merely be functioning as the business of an individual. It needs to be functioning separately and be separate from the business owner. And if it's not, then it's really not a true corporation, and the state can pierce that corporate protection in order to reach through to the corporate owners. Okay, pardon me. So an S-corp functions like a corporation, but is taxed like a partnership. It's just a kind of corporation that grew as business owners were trying to find a way to avoid double taxation. It's got its limitations: no more than 75 shareholders. It's formed under federal law, which distinguishes it from the other forms of business organization that we've been looking at. Corporate law is state law. Really, the only federal law we've been dealing with has been tax related. So an S-corp is formed under federal law. It's really a creature of the tax system. Shareholders report income as personal income, and the corporation it's formed under federal tax law. It's considered a corporation for liability purposes and for management and control purposes, but for all other purposes, not for all other, for tax purposes, it functions like a partnership. So limited liability companies, it's a business organization with the limited liability of a corporation, but taxed like a partnership. It's formed under state law. LLC owners are members. They pay personal income tax, and there's no limitation on the number of owners. So we have some special forms of business organizations. The cooperative, which is an organization formed by individuals that might create market products. The joint stock corporation and business trust. I'm going to allow you to read about that in your book. I don't lecture heavily on it. But I would like you to know the syndicate. A syndicate is formed just prior to an initial public offering, and that syndicate is an investment group, and it is financing the very large issuance of stock. So the syndicate is formed initially, and then when the stock goes public and trades on the open market, that's the secondary market. So the primary market for any publicly traded stock is the investment group, the typically group of investment banks that get shares and pay for shares under the syndicate for that particular issuance, like, for example, an equity issuance for Facebook. And that syndicate will include the investment bank that is managing the IPO, and other smaller brokerage firms that will be part of the very large project of financing the issuance of this public stock. And then that is eventually the shares go public the morning that trading opens, and then the shares trade openly on the secondary market. Joint ventures, as I mentioned and we looked at briefly in Chapter 6, are two or more persons or corporations created for a specific business undertaking. And so here, a joint venture, the best examples, I'm sure there are good examples all around, but I really like the example of the oil joint venture. I believe it was oil exploration that took place. It was a U.S. oil company, a European oil company, and a Russian oil company, and they were engaged in a multi-year joint venture to find oil. And then when Russia and Ukraine blew up and started having friction, that joint venture was imperiled. I really don't know what the status is of it is now, but you can imagine the advantages of a joint venture to explore for oil. One company may be bringing drilling expertise. Another company may be adding investment resources. And the third company may be bringing expertise in the region and management expertise. Forming the joint venture, it's a short-term project, an undertaking that you don't need to form a corporation for. You don't need to form an international corporation for. You can form a joint venture and agree through that joint venture agreement on how resources are to be split. One company is going to contribute investment resources. A second company will contribute the expertise and all the management for that joint venture. The CEO, the chief accounting officer, the chief information officer. And then the third company is going to be very operational and on the ground and doing the drilling and providing labor and equipment and expertise in that area. So joint ventures can be created between persons, but I like the example of corporations because they're not interested in forming a new them, but they do want a joint project, and that is efficient and collaborative and can create profit for all three businesses if conducted well, limiting liability and exposure, using strengths and in a joint undertaking that doesn't, that if successful, it could be very profitable. Okay, and then finally a franchise. So we all know, well, I don't know, do we all know what kind of franchises they are? McDonald's is a franchise, Quiznos is a franchise. Owning a franchise is really signing the agreement between the franchisor, which is the big corporation that holds the trademark and the trade name and runs McDonald's, and you, the franchisee, who's going to sell goods and services and do everything that the agreement says and not violate it so that McDonald's can look the same everywhere. Always make your burgers this way and always mix your milkshakes that way and always advertise in this particular way under the franchise agreement. McDonald's, Subway, 7-Eleven, Pizza Hut, all franchises. And there are lots of advantages to the franchisee. You get help from the big guys. You get to use the trade name and the trademark, instant name recognition, instantly advertising. That's awesome. But there are burdens as well. You don't have creative control over the business. You might lose the franchise if you breach the contract. You have to meet all the fees and contractual requirements. The franchisor gets to have increased income, charge a fee to the franchisee. It's a little less risk, but also could be liable for a franchise that does bad things, or if a franchisee quits, the franchisor exerting too much control over the franchisee bails, and then the franchisor is responsible for it. All right, so let's apply some of these concepts. In the case opener, we have Dunkin' Donuts, who revoked Bayani's franchise, and were they lawful when they did it? And the facts were that Dunkin' Donuts notified Bayani that his franchises were violating parts of the franchise license agreement. There was a repeat of the incidents and failure to cure over a substantial period of time. So Dunkin' Donuts demanded termination of both of the franchises. Were they right in doing that? Looking at the facts, Bayani owed $33,000 in delinquent fees, failed to cure the financial default. There were health and safety, sanitation violations, pests, improper storage, refrigeration, improper food and chemical storage. And Dunkin' Donuts, as a franchisor, is able to establish standards, and when they're violated, able to terminate it's essentially a breach of contract, is it not? It's a breach of a promise that Bayani, as a franchisee, made to comply with the franchise agreement. And when that, and as long as Dunkin' Donuts complied with the franchise agreement as well, and any applicable franchise law, then they were within their right to terminate the franchise for failure to perform, essentially, and for violation of the contract. So it's really an opportunity, when you read about it, to understand, the rights and duties of each side of a franchise agreement, and that operates very, very similarly to contract law, but also franchise law within the state where the franchise operates applies as well. So lots of different kinds of franchises. I'll let you take a look at those in your book. Global franchises, McDonald's, UPS, Pizza Hut, international franchises. All right, so let's take a look at the Meyer v. Christie case. Let me adjust this slide ever so slightly. So Meyer v. Christie is a breach of a joint venture. There's a typo on your slide. It's a breach of a joint venture agreement. And the joint venture agreement was oral. And as you read this case, what I'd like you to spend some time looking at, it's a very short excerpt, but it's a good excerpt. It's case 35-1 in chapter 35. And we've really been, in this course this summer, looking at how these cases develop rules and tests that can then be followed by subsequent courts. So the whole point of common law and many of the Supreme Court decisions is to create a body of law that can be understood and followed by subsequent courts. And one of the main things the Supreme Court does is resolve disputes about what the proper rule is and what the proper test should be. So in the Hertz case, we learned about testing for how do you know where a corporation exists, and it exists where the nerve center is, not necessarily whether it's headquartered. In the Goodyear v. Dunlop case, we looked at how do you determine, whether a foreign subsidiary of a U.S. company can be sued in a particular state. So if a couple of Goodyear tires showed up in North Carolina, did that create enough of a connection? And those tires came from the Luxembourg subsidiary of Goodyear Tire, the Turkish subsidiary of Goodyear Tire. Was that enough of a connection to force Goodyear into court in North Carolina when the accident happened in France? So here I would really recommend you read this case because the court spells out, it's the 10th Circuit, it's a court of appeals, it's a 2011 case. The court is pointing out a rule that it set forth previously in another case called Terra Venture, and then it continues to not follow that. So I'd like you to look at the facts that you're given in this case and look at the rules set out in the previous case in Terra Venture, 5 determining factors of whether a joint venture exists, and see that some of the factors are missing in the Meyer's case. The facts don't support that there was a sharing of expenses, profits, and losses, and ask you, how did the judge come to the conclusion that this oral agreement was a satisfactory joint venture agreement? And this is our first kind of tiptoeing to critically assessing, was the judge's reasoning strong? Did you find that it was him just making it up? I don't know what you'll get if you get a true sense of that. I will say that, an oral, and did the judge find that the oral agreement violated the statute of frauds? Did this joint venture agreement need to be written? Anyway, take a look at it. You have the issue and the facts here, and I think what I'd like you to do is spend some time thinking about whether this was a good decision in this case, and begin to develop those skills of critical legal analysis where you read what the judge wrote, but you can also read critically, understanding that some arguments are strong and some arguments are not strong, and being able to identify when that takes place. Okay, moving on. This is a fun case, Mary Kay. So in 1980, Janet Isbell became a beauty consultant for Mary Kay. And over the years, she continued her affiliation with Mary Kay until in 94. She rents a space in a shopping mall and was specifically told that certain activities should not be conducted in that space. Now, this is an older case. It's decided in 1999, but you can kind of look at it with your 2015 eyes and say, corporate told her not to do certain things that would give the impression that this rental space in this mall, which was really a training center, would be a retail space for Mary Kay. So if it had the same design as a Mary Kay store, if the products were displayed in a particular way, certainly people in the mall would get the sense that this was a store that they could shop in. And corporate was very express in telling Janet Isbell how the space could legally be used. When she misused the space, they notified her that their agreement with her was terminated. She claimed that that termination violated the Franchise Practices Act of the state of Arkansas, and that in order to terminate the franchise properly, they needed to take certain steps, but they did not do that. So I really like this opinion because the judge sets out some of the very specific questions that must be answered before they can really answer what Miss Isbell is suing for. So Janet Isbell is saying, you violated the Franchise Practices Act by terminating my franchise improperly. And the judge takes a step back and says, hang on, are you a franchise? You know, what is a franchise? Let's look at, before we determine if the franchise, and remembering that people can sue for anything, okay? Just because somebody sued, and it makes it all the way to the Supreme Court of Arkansas or any Supreme Court, the court must satisfy itself that they've cited law that actually applies to the facts in their case. And then sometimes that is the dispute. Can this dispute at all be brought up under this particular act, or should the person sue under something else? And so what I really like about this decision is that it forces you to walk slowly with the judge, deliberately thinking about the issues. Number one, does the Arkansas Franchise Practices Act even apply here? Okay, and then even if it does, if Janet Isbell is a franchise under this act, what else do we need to look at? Well, we need to look at the parties' agreement. So the agreement was in 1980 to be a consultant. Did she become a franchise? It's possible, I imagine. I don't know what Arkansas franchise law says. But I would ask you to take a look at this case a little bit more slowly, walking with the judge. I think it's well written, and not all the cases in your book have this kind of deliberate analysis. I'm not saying the judge made the right decision, but I would like you to be able to follow along saying, oh, he asked this question and then answered it. He asked that question and answered it. Always taking the issue and applying the facts of this particular case at hand. And this is, once again, us practicing those critical legal thinking and critical analysis skills that we've been working on this summer. I provide a brief slide to kind of point out some of the judge's reasoning, but I also ask you to spend some time with this case and take a look at it so you can appreciate the analysis as well. Okay, thank you. That's chapter 35.